I'm joined by Councilmember Marquise Harris Dawson and Councilmember Mitch Englander. We apologize for the hour-long delay. We had a long council meeting, which delayed a number of other committee meetings, but here we are. We'll start off with the multiple item comment cards, which there are none. Item number 3, we will move on consent with no objection. We've been joined by Councilmember Blumenfield. Item number 4, we will move on consent.
Councilman, on item 3, I think you need to forward it to the city attorney for the ordinance.
Okay, we'll incorporate that into the motion and approve it again without objection. Item number 5, we will continue to a date uncertain at the request of the applicant. Item 5, we will continue to a date uncertain at the request of the applicant. Item number 1, we will take up, and it's a report from the Director of Planning, Mr. Bertoni.
Thank you, Chair. Members of the committee, no report this week, but happy to answer any questions of the committee.
Okay, thank you very much. Let me go back to item 5. I know I was just looking at the comment cards here. We have continued the item at the request of the applicant. We normally do not hear public comment at this time. We reserve it for when we actually hear the item. Council District 5, are you here? Any rep from here? Nobody here. Okay. On item 5, is it okay we hold the public comment till we have the item back before us? We have about 4 or 5 cards on that. I usually try to reserve the public comment on any item when the actual item comes up, because it might be unfair to people who are here at that time when we're actually going to vote on it. But I'm not sure if you had any special request or not.
Good afternoon, Councilmember. Faisal Sarah on behalf of Councilmember Paul Koretz. I think that would be fine, and I think what we would offer to everyone that's here on this item is we can host a meeting.
Okay, that'd be great.
In our offices to kind of hear everyone out.
Great, thank you very much. We'll do that. Thank you. So we'll still continue number 5 to date uncertain. Item number 2, if we could call that to order, please.
Yes, Councilman, item 2 is a city attorney prepare ordinance relative to the regulation of party houses in the city.
Thank you. And for the record, we've been joined by Councilmember Curran Price. Is there a report on this from staff?
There is a city attorney report.
City attorney report? Okay.
Yeah.
Good afternoon, Heather Aubrey, City Attorney's Office. Would the committee like an overview of the...
Yes, a brief
ordinance?
one, please. Just
Absolutely.
a brief overview.
So the draft ordinance would prohibit loud or unruly gatherings in the city of Los Angeles at residential properties. Loud or unruly gatherings is defined in the ordinance to include a variety of various forms of conduct, all of which are already illegal under either local or state law. Things such as public urination, assaults, batteries, littering, things of this nature. These and other forms of conduct will constitute loud or unruly gathering under the ordinance, and there will be prohibited under this measure. Those in violation would be issued a citation pursuant essentially to the ACE ordinance. So it would be an administrative citation with a fine structure that is currently higher than is currently allowed under ACE, and which is the reason why there's another aspect to this ordinance before you, which amends the ACE ordinance to allow for the higher fine structure. So responsible parties and owners of the property will be subject to citation, as well as partygoers who engage in the loud or unruly conduct. A posting is required under the ordinance for 30 days, during which time any removal, defacement, or tampering with the sign would be subject to a separate penalty. And the fine structure is such that any subsequent violation within a year would lead to higher fine amounts. And the first fine as drafted is $500, and it escalates all the way up to $4,000 for a fourth or subsequent violation. LAPD is here to answer any questions as necessary, and I'm happy to entertain any questions as well.
This is Dave This is Dave Michelson with City Attorney. Thank you, Heather. That accurately describes the ordinance. Let me just add that when this was at Public Safety Committee recommended a few modifications, one of which is to start the administrative fine schedule instead of $500 for a first violation to make it $100. And then the second violation, instead of $1,000, would be $500. Then it goes to $1,000, $2,000. Fifth violation was $4,000. So that, again, is a recommendation emanating from the Public Safety Committee, along with a few other tweaks as well from that committee.
Great, thank you. And thank you very much for raising those issues, because we were intending in incorporating those amendments, and we would like to do those up front before public comment. So thank you. Anything else?
Other one, and I'm sorry, Dave, did you mention the other one had to do with the with starting the clock again with the removal, with the posting issue? If there is any removal or defacement of the sign or tampering with, the 30-day posting period would start again. And that was another amendment requested at Public Safety.
Right. And the third amendment, which I think was Councilmember Englander, actually, Public Safety, was to make sure that the size of the signs and the location and the color is also spelled out. So those are the three recommendations coming from Public Safety.
Okay. Thank you very much. Anything else? No. Thank you. So we'll first go to public comment and start off with Council District 2, Nick Grief. Yeah.
Good afternoon, council members. Nick Greif, Director of Policy and Legislation for Councilmember David Rue. Thank you for hearing this ordinance. We are excited. Apologies, coming off a cold. We were excited that after a number of years, this party house ordinance has been able to clear both Public Safety Committee and Planning and Land Use Committee to go to the City Attorney's Office and return with the ordinance that is here before you today. As noted a couple weeks ago, Public Safety Committee heard this ordinance and approved it with the recommendations that were noted. Councilmember Rue is very supportive of this ordinance and would like to thank a number of people that have been responsible and helpful in putting this forward, 4 of which are sitting in front of you today. Particular thanks to Heather Aubrey and the City Attorney's Office for their work, Steve Houchin, the neighborhood prosecutor who's been dealing with this in the neighborhoods in our district in particular, and LAPD for their work in both enforcing and coming up with the pieces of this ordinance that will make it easier to enforce in the future. To talk about the public safety changes, the one main addition that was put forward that actually stemmed from discussion that came out of this committee when it was heard here previously earlier this year was the addition of the $100 introductory fine. This was added out of the concern that a first-time offender being hit with a $500 fine for what could just be a birthday party that got a little out of control might be seen from members of the public as a little too strong. Wanted to ensure that that was not the case as this went into force and was being enforced by LAPD, but that the future fines that were put on folks who continually, repeatedly offended did escalate at a very quick rate, which is why it goes from 100 to 500 all the way up to 4,000. We have heard from a number of constituents since that committee and from members of this committee and others that they think that there are some party houses that are egregious enough that a higher fine level at the top end may be necessary, and we would ask and are very amenable to adding an $8,000 fine level at the top end if that is something your committee would like to do. If there are any questions, I'm available. Otherwise, we thank you for your support, and Councilmember Rue.
When you're suggesting $8,000 at the top end, that means for egregious offenders? Or
Yes, for repeat offenders.
repeat offenders?
The sixth violation, essentially.
Okay,
So it's
the sixth violation. Okay, I want to make that clear. Okay.
Great. Thank you very much.
All right, thank you. All righty, we have three other comment cards. George Scarpellos, Jeffrey Dowden, and Mary Ledoy. Welcome.
Hey, thank you very much. My name is George Scarpellis. I'm the Vice President of Hollywood United Neighborhood Council, and I am also the Vice Chair of the Planning and Land Use Management Committee meeting. We are very much in support of this ordinance. It's been a long time coming. We pushed a lot of for the council to work on something like this and to draft something because many of our neighbors in our community find a scourge of party houses that are not houses, they're venues. They hold product launch events, they have step and repeats, they do big corporate types of promotional things. And it's important that we know that these are not simply somebody throwing a quinceañera or a bar mitzvah or a campaign fundraiser for that matter. They're throwing, they're like a nightclub, and they are putting these kinds of events in single-family dwellings in residential areas with substandard streets without the proper parking and such. And so it's important that we provide the amount of time, amount of enforcement to help them, our police and our city, to make sure that these kinds of things don't continue. I have some pictures. I'm sure you've probably seen them all. I know Councilmember Englander has seen them, of these kinds of events.
Thank you.
That happen in the neighborhoods in our communities.
Thank you very much. Jeffrey and Mary?
Hi, my name is Jeff Dowden, and I live across the way from 4 party houses in a row. They were specifically designed not as residences, but as party venues, and they become very disruptive. I appreciate the time that the city attorney and the city has put into crafting this ordinance, and I'd encourage you to pass it. I would like to see stiff fines for these guys because the repeat offenders are doing it because it's simply the cost of doing business. And they make a lot of money doing this with no regard to the safety or quiet nature of the Hollywood Dell. It's a dell, but it's been turned into Sunset Boulevard. Thank you.
Thank you.
Good afternoon. Can you hear me? I'm
Yes.
Mary Ledding. I am a member of the Hillside Federation representing the Hollywood Dell, which supported this ordinance. I've been working on this for 5 years. It started in 2012, and we're delighted it's finally to this point where it's going to get passed. The one thing, there's 2 recommendations I saw coming out of the Safety Committee. The first one I absolutely agree with, the reconstituting the 30-day period once somebody's tampered with a sign. But the second one, I see no public safety benefit to reduce the fine for a first offense. There's no benefit to, say, make it easier so they can continue their first offense. This matter was studied and recommended by the city attorney to be $500 to follow the Newport Beach law, and I don't see any reason why we shouldn't follow the original city attorney report on this, which was $500 for the first offense, and follows the other jurisdictions which the city attorney was told to report on and did so. Thank you.
Thank you very much. Okay, any questions or comments from committee members? Mr. Englander.
Yeah, so we do have the that higher tier in there now, as they asked for.
So currently, the top tier is a 5th violation, which ends at $4,000. That's what came out of public safety, but there's no problem if you want, from a policy standpoint, to add a 6th tier, or 6th violation, which would be $8,000 if that's the council's
I'm
decision.
fine with that. I would move. I mean, at that point, if somebody's already paid the $4 and they're continuing to do it,
It's in the
I'm
course
fine
of
with
1
that.
year, so that's a
All
lot
right.
of...
We've got a second on
There's
that.
been a motion, Mr. Englander, a second by Mr. Blumenfield.
All right, and then, Mr. Michelson, in the interest of equity, just to make sure that there's enough parties and there's capped out in every district on how many birthday parties can actually occur, and the enforcement tools and mechanisms to ensure that those parties are under control and they don't have too many candles on the cake. Can you address that issue?
So it,
No, I'm kidding. All right, that
okay,
was just
good.
based
I
on
was
the
like,
discussion
I
this
love
morning. I
birthday
want to see if
parties.
you're still
I don't know,
alert.
my
Like, really?
one-year-old. You had me going there.
You were ready. Really? One clown per okay, so I think
One clown per
one
party?
per party. That's it. We've already got 15 in these chambers, so one per. No, okay. So thank you very much. Appreciate that.
Mr. Blumenfield?
Thank you. A couple questions. The fines at first time versus second time, is that a difference between the responsible party and the property owner? And the reason I ask is I'm imagining situations like the house is a party house and they advertise it on Airbnb, and the property owner knowingly markets it as a party house, but then you're going to have, it doesn't seem fair that the person who rents it the third time gets a different treatment than the person who rents it the first time, in that they're not aware that it's been a party house. So can you have the tripling or the doubling happen independently, or do they have to go together?
No, they're independent. I think I understand your question, council members, and it's a good question. So an owner, once on notice, will get that repeated violation and at escalating penalties, no question about that. The person who's a responsible party who rents the property through Airbnb and just rented it once and violated the law, they're only going to be subject to that first violation. Now, the owner will be subject to the higher violation if there's been prior violations, don't get me wrong, but the actual responsible party who rented it just that one time is not going to be responsible for the other history.
And similarly, if you have a, quote, responsible or irresponsible party just having party house here, then here, then here, even if they get caught at a second house, if they are the responsible party for that party, will they have an escalation?
Yes, that's a great question as well. We did write it to account for that. So if you're, I like the way you phrase that, an irresponsible party, frankly, and you are doing this at multiple homes in the city of LA, it doesn't matter. Each time the LAPD catches you, that's now going to be an escalated fine. It's your second, third, fourth fine. Even though you may have only done it once in that particular property, it still will count against you at other properties in the city throughout the year.
Good. That makes sense to me.
Yes.
What I didn't understand, are we making anything newly illegal that hasn't been illegal?
Well, that's a great question. No. I say that for the following reason, and my colleague Heather Aubrey should jump on as well. If you look at essentially the list of items that make up loud or unruly conduct, all of these items, A through K, are in and of themselves against the law in some fashion or another. What this ordinance is doing, though, is creating an administrative citation penalty that has escalating and larger, therefore, dollar amounts that are associated with those citations, where before this ordinance, the A citation program, especially these higher dollars, would not have been available. The only tool that would have been available if someone was violating A through K, they could be cited individually, but the actual sort of party house environment with the responsible party and the owner, the city had a hard time getting at those folks, let alone without a tool that allowed an administrative citation and an escalating administrative citation to be employed.
Because previously you'd have to have a misdemeanor or something about one of those actions, right? Which is often a harder process, and the police don't, it's a lot more paperwork and everything else. So this is, nothing new is illegal. This is just if you can check off one or more of these boxes. Is that, correct me if I'm...
I think that's an appropriate way to phrase it. We do have LAPD here, so they can speak to that as well.
I would say there is a new layer of illegal conduct here, and that is defining a loud or unruly gathering as prohibited conduct specifically under the code. So, and with that violation coming along with it, the ACE violation and the higher fine structure then is available for the criminal violations that constitute the loud or unruly conduct. So while the loud or unruly conduct itself, the various types of conduct that constitute that are already illegal, it is creating this new prohibition, this new illegal conduct, if you will, that does create a new layer of of something new that's specific to party houses.
And that's a better way to put it. I think my colleague Heather Aubrey is correct. I mean, there is a new phrase, which will be in the municipal code, of loud and unruly gathering, which wasn't there before. And if you violate by having one of these loud or unruly gatherings, there'll now be a penalty associated with it. So in that sense, it is new, yes.
And what is the appeal process for something like this?
So it's really through the city's administrative citation enforcement program, which has been up and running for a couple of years now. So when someone receives that citation, they have the ability to either just pay it or the ability to challenge it through the ACE program administrative hearing process, which is fairly well oiled at this point. We've been using it with great effect with our partners at LAPD, with Animal Services Department, park rangers are using it, LAFD is using it for, I think, brush clearance. So there's a whole
And that's
fairly
a due
robust
process. You appear before somebody, or how does that work?
So there's the, ultimately there's an administrative hearing officer that you can appear before and state your case as to why you think the citation should not have been issued to you, why the dollar amount should be different, why there might be mitigating circumstances. And the hearing officer is a neutral arbiter and will listen to both the city side of it and to the person who's been cited the violation, and they'll make a decision. So that system's already in place and up and running.
And why do the fines reset after a year?
So there really needs to be some period of time by which, from our perspective, sort of a reset button might be pushed. In other words, if you get an initial citation and then 13 years later you happen to get a second citation, a fair amount of time has kind of gone by, and from our perspective, it's probably appropriate to have a reset somewhere in there. So 1 year seemed logical. Newport Beach used 90 days for a reason I don't know. I think the council has flexibility. If you wanted a different period of time, you could certainly do that. But just having it open-ended forever is maybe
So does the
problematic.
reset, so let's say you have an illegal, you get cited
Yeah.
in January, and then you get cited again in December. So now you're times two, you're at $500. And then you get cited again in February. Are you now on, did your first one reset away?
It did not. That'd actually be the third violation. The way we've set it up, in a sense, it's like a 1-year probation.
Right.
So the only way to get out from under that 1-year probation is to not have a violation for a full, any violation for full 12 months.
Right.
So that way it is rolling. Yes.
So if you get a violation within those 12 months, then whatever was in the previous 12 months is going to stick with you for the next 12 months.
That is correct. In essence, you have to have avoided a violation for a 12-month period to reset the clock completely.
Right. And in terms of the fines, are they being used for recovery of staff time? How do we always have that difficult thing when we get sued about fines. How do we justify the fine structure with the nexus and nexus requirements and fees?
Well, so the good news is, for the most part, the City Council doesn't have to worry about nexus when it comes to setting fines and penalties. City Council has to worry about nexus when fees are extracted, a building and safety fee, for instance, to replace a sink in a bathroom. There has to be a fee study done by the city that shows that costs roughly $150 of city staff time to issue that permit. So the city cannot charge more than the $150. When it comes to a sanction and a penalty for violating city law, it can't be so high that the courts might view it as, what's that word we talked about?
An excessive fine.
Sort of an excessive fine. There's some constitutional limits. It can't be $100,000, for instance. But there's no necessity for the city to establish that
Right.
the fine was based
That makes
on staff time.
And
As long as it's relatively reasonable, the courts typically will uphold it.
and the 8,000 for the fifth will still be in the reasonable range.
Well, I would argue if we were challenged in court that this was a sixth violation, in essence, in a 12-month period, and the city has every right to try to motivate individuals not to continue to violate the law, and the first 5 violations didn't get their attention sufficiently, and therefore the dollar amount has to go up. So I think a court would probably sustain an $8,000 sixth violation. I think it's relatively reasonable.
And then the posted, I didn't quite understand how that works. How big is the posted document when they have the violation? Where does it have to be placed? Is it in someone's front window? Is it in their backyard?
So in the existing version of the ordinance, which was originally transmitted before public safety took action, it just had to
Be at the front entrance.
Be at the front entrance, but there was no discussion about size or font size. One of the things that the Public Safety Committee recommended as a change is actually putting language into the draft ordinance that talks about actual size and maybe additional information about location. So if that's what full council ultimately also agrees with, we will quickly retransmit the draft ordinance with all the changes full council
So as it stands now, there's nothing that talks about size or requirements. We would just make up the posting in a regulatory fashion. We're not dictating it as a council, but you're saying
Public Safety suggested that there be a change in the ordinance that actually talked about a specific size versus just kind of leaving it up to the bureaucracy to come up to the size. So if that's what full council ultimately acts on, we'll definitely bake into the final version.
And is it a sticker that goes on the door or on the window, or is it like a lawn sign, or what is it? Help me imagine.
The way it's
what
currently
supposed to be.
drafted, it would be actually posted on the front door of the property. So mostly the change would be making sure it's big enough to be seen, say, from the sidewalk for an average home and an average parcel size. And so we would actually put that in the ordinance.
Okay. And obviously that's legal. We're not going to be.
Well, sure, that would be legal. And indeed, if you're about town and you see someone with a construction site, for instance, there's city laws about posting for construction sites. The city laws about posting a CUP on the front of a business who's looking for a liquor license. So it'd be kind of similar to that.
Well, last question, just how do the complaints actually get processed in this? These are not multi-night, it's going to have to happen pretty quickly. At nighttime, someone calls it in. Is it just straight through LAPD? Is there any special process, other process that would happen?
Right. Well, the good news is, and if I get this wrong, friends here at LAPD will jump in or Heather will jump in. The good news is this ordinance, once enacted by the city, will just be another enforcement tool as part of the ACE program, which LAPD has been utilizing and implementing for probably 2 years at least now. The LAPD officers carry, in essence, 2 sets of ticket books. One of them is an ACE ticket book. So when the LAPD officer decides in their discretion to write the ACE citation, they write the citation, they hand it to the violator, and then the rest of the ACE program moves forward from there.
And they can write the citation without having to document any of the other enumerated illegal activities. They don't have, do they have to write a citation for one of the enumerated
It is best if the citation includes some degree of detail, such as if it's noted A through K, which one of those might have been noticed, in terms of the ingredients that would make up a loud or unruly gathering. So some basic things that the officers do.
Any of those ingredients are prosecuted. They could be prosecuted on, right? So,
That is correct.
but we're presuming that they're not. The city attorney is not necessarily prosecuting them on the individual ingredients. We're just writing the ACE citation. Or,
Correct.
Or is there discretion, and when would the city attorney choose to prosecute based on the individual ingredients versus or in addition to the ACE citation?
So there would not actually be a prosecution with respect to any ACE citation. It's an administrative citation that's issued.
Get that.
So in that context, and it's really up to the discretion of the LAPD officer as to how they want to write it up as to which violation of the Muni Code, whether it's this violation of the Muni Code or another violation.
It would definitely be discretionary, and I'll certainly let LAPD jump in as well, but I just wanted to point out as well, Councilman, that there is a provision in the ordinance that allows for any violation of the key provisions of this ordinance to be prosecuted as a misdemeanor in the discretion of the city attorney's office. So, right, instead of. Now, you can't have both, but you can have that election.
You can't have both.
Correct.
So you can't, if an officer goes in, sees 10 of the ingredients there, public urination, this, that, and the other, writes them all up, and then writes an ACE citation, then they can't be prosecuted for the ingredients?
Well, what tends to happen when it gets to our office, if it turns out that this particular responsible party or owner has had many violations over the years, and maybe this one instance is particularly egregious, the office of the city attorney has the ability to, instead of then moving forward with an ACE citation, actually pursue a criminal misdemeanor filing. It's a pretty rare occurrence, but that option is always available.
Even though they've already been written the ACE citation. So that doesn't inoculate them. Receiving that ACE citation is not an inoculation from all of the...
There is the potential it would be pursued through criminal channel, yeah.
But that would have to be a determination by the city attorney.
The prosecutor, not
by
the
the
civil side
prosecutor,
of the
I'm sorry.
office. That's
By
right.
the prosecutor before they went ahead and
And process the ACE citation.
although the person receives the ACE citation, they go to someone's house, they write you an ACE citation, they quickly pay it, say, oh great, $100, they pay it. Are they now not inoculated from all the other crimes?
If they pay the ACE citation, then the ACE citation program has been utilized and implemented, and there would not be an opportunity for that particular instance to then criminally prosecute it.
I don't know. I highlight that as a potential issue, that because you don't want folks to get smart and say, great, I'll take the citation, inoculate me from all the other stuff, and then, go wild because I'm not going to get prosecuted.
Right.
I don't know how to avoid that, but it's just...
As a practical matter, that decision would likely be made very early on, such that the ACE citation wouldn't be processed quickly enough for that to be a done deal, such that prosecution would not be available. But I understand the point you're making.
Thank you. Or do you want
you.
to add?
I can address a little bit of it. I'm Pat Butler from DSVD. A lot of the Section A through K wouldn't hold the responsible party responsible. It would be a party guest. And this actually goes after responsible party and the owner. So, it's a tool for the uniform officer, getting that radio call, which there are many radio calls, and they can handle it fairly quickly. If we had a situation where there were a lot of things happening at a location, we would probably do an investigation over a series of months and collect a lot of violations and then present a case for criminal filing to the city attorney. Instead of ACE, right?
And when the officer writes that ACE ticket, does that shut the party down?
Hopefully.
Well, yeah, the ordinance actually lays out a number of remedies available to the officers who are responding, one of which is an ACE citation to the responsible party or the owner. The LAPD has its other sort of toolkit of enforcement options, including if there's other violations going on at the property, to act on those violations that the officer is seeing, possibly to try to abate right there and then and have folks be ordered to leave the property.
Thank you, Mr. Chair. Thank you.
Mr. Harris-Dawson.
Thank you so much, Mr. Chair. A couple of questions on this, and you all may have covered this in a report, and I may have missed it, but can you talk for a second how, if at all, this ordinance works together with the exotic animal ordinance that we did sometime last year, which effectively talks about many of the same type of events?
I'm not sure that it's contemplated that they work together per se, but certainly they may well be designed to address some of the very same issues that we're seeing in certain communities in particular.
Okay. I'd be very, very curious about how those work together. And then I have a question that's probably as outrageous as my colleague Mitch Englander's, but I actually want an answer to this. If a homeowner, house owner, declares bankruptcy at the time that we impose this fine, and they go to court and ask for a restraining order against the city of Los Angeles' ability to enforce land use policy, have we written anything into this policy that would stop a bankruptcy judge from preventing the city of Los Angeles from enforcing its land use policy?
So, Council Member, let me try to address that. First, the bankruptcy laws in the country are federal laws, and they're going to trump anything we do here at the local level, number one. That, I guess, is the bad news. Number two, which is hopefully the good news, and it's something that we are literally researching as I speak, as to what is the reach of the authority of a bankruptcy judge when it comes to a municipality like the city of LA exercising its police powers. Can a bankruptcy judge actually take action that would in any way deter or slow down or hinder the city's ability to exercise its police powers under the authority granted to it by the city charter and the state constitution, frankly. So it's a great question, and it relates to a question that we spoke about earlier today, and so it's timely in that sense, but know that we are taking a very close look at sort of, as I say, the reach of a bankruptcy court when it comes to a municipality's police powers.
Thank
Thank you. Any other questions? Okay, so the motion before us is to approve the ordinance and request the city attorney to revise the draft ordinance to include the Public Safety Committee amendments relative to the violation fines, and also to add the amendment made by Mr. Englander to have the sixth violation of $8,000.
And also the posting, the 30-day posting.
The 30-day posting?
Yeah, that was embedded in the Public Safety Committee recommendation.
Okay, we'll include that in there. Okay. All righty. Any objections? Seeing no objections, so ordered. Thank you.
Thank you, Councilman.
Thank you very much for your presentation. Item number 6.
Item 6, Councilman, this is an appeal by Henrietta Conrad from the action of the City Planning Commission relative to the approval of a vesting track map for a 129 condo project with 15 very low-income units in CD 11.
Okay. Staff here, a brief presentation on the item, please.
Sure. Thank you very much, committee members. Oliver Neprin with the Department of City Planning. As was stated, you have an appeal before you of an approved vesting tentative track map. The appeal is primarily with regard to the environmental clearance and specifically as it relates to the air quality analysis that was conducted, as well as some concerns relating to the traffic analysis regarding the alley vacation. We believe that the environmental analysis that was conducted for the M&D is adequate. There was some supplemental material that was submitted to the record regarding traffic and regarding air quality, which we think further supports the conclusions of the environmental. Ultimately, we don't believe that the appeal raises any issues that would warrant any new mitigation measures or the filing of an EIR. So as I stated, we believe that the environmental mitigation negative declaration that we adopted is adequate. However, we would also like to put forth before you consideration of the adoption of a SB 375 statutory exemption. This is a new statutory exemption which the state has offered, which would allow for projects such as this to be exempt from CEQA. Specifically, the SB 375 exemption intends to exempt projects which are sustainable, using certain types of environmental mitigation measures as it relates to the air quality, the energy efficiency of the buildings, their transit-oriented location. In addition, SB 375 also requires that projects provide an affordable component to the project. This project fulfills all of those requirements, and so staff has put forth to you consideration of the adoption of the SB 375 exemption, which we think would further support the environmental clearance that we've done for this project. There's also some additional consideration for the findings, which I believe the applicant may want to address. We believe that the vesting tentative track map that we approved adequately meets all the findings for the vesting tentative track map, including the vacation of the alley. However, as I stated, the applicant may have some additional information they want to provide on that behalf. We're here for any questions that you may have.
Thank you. Start with public comment, and first is from Council District 11, Len Nguyen.
Hi. Thank you, Chair and committee members. My name is Len. I'm a senior field deputy for Councilmember Mike Bonin, 11th District, covering West LA, where the proposed project would be sited at Pico and Gateway. Councilmember asked me to attend today to attest to the community outreach efforts between the applicant's outreach team, neighbors, and the West LA Sawtell Neighborhood Council. Office expects applicants to work closely with the community in which the project is located. We ask that applicants consult with community members and the neighborhood council as early in the process as possible. This applicant worked with the community from the beginning to try and craft a project that was sensitive to the surrounding neighborhood. Over 2 years, the applicant's outreach team attended nearly 20 meetings. They made changes to the massing and eliminated retail to address concerns of both the surrounding neighbors and the neighborhood council. The Land Use Committee of the Neighborhood Council did support the project, while the West LA Sawtell Neighborhood Council full board could not reach consensus on a motion to support or oppose. The council member appreciates that this project will provide much-needed housing that is very close to the Expo Light Rail Sepulveda station. Would like to express our gratitude to the neighbors and board members who participate in the process, and based on that work with the committee, the council member believes that it is appropriate for this project to move forward, and he respectfully requests that the committee deny the appeal of the map. Thank you.
Thank you. Okay, first with the appellant, Craig Collins. Appellant has 5 minutes to speak. Thank you.
Thank you. Good afternoon, council members. I just wanted to, first of all, let you know that I'm a partner in a law firm called Blum Collins, LLP. I'm appearing on behalf of the appellants. I just want to hit the highlights in some of the letters that we previously submitted on this project. First of all, the project requires the vacation of an alley. That's an illegal and an unconstitutional gift of public funds, and so it's improper to convey that city property to the developer. Second of all, you heard in the presentation that there was perhaps an exemption under what was referred to as SB 375. That exemption doesn't apply, in part because this project is being built on what is now open space. The alley that exists there today is open space available for public use, and that's going away as part of this project, and therefore this project does not meet the requirements of the exemption. I think perhaps for that reason the applicant did an MND, even though the exemption wouldn't require him to do an MND. The MND is not adequate. This is a big project. It requires an environmental impact report. There are serious impacts that need to be evaluated, which are referred to in our letters, including air quality. And we submitted detailed air quality analysis to explain why the MND is just not adequate for this project. Now, I'm not aware of how many residents are here today. I was here a week ago when this item was first on the agenda, and I know there were over 15 residents that were here to speak then. I hope they've all made it back today, because there's widespread opposition to this project among people who live in the area and who are affected by this. So we urge the council, the Plum Committee, to grant our appeal and to reverse the decision and require a full EIR. That doesn't mean that the project can't be done in some form. It just needs to go through the process of analyzing all the environmental impacts, so that the people who live in the area know what's coming at them. That's the purpose of the Environmental Quality Act. It should be followed here. Thank you.
Thank you. Applicant Dana Sales and Dave Rand, you have a total of 5 minutes.
Good afternoon, Mr. Chairman, Honorable Plum Committee members. My name is Dave Rand with the law firm of Armbruster, Goldsmith & Delvac, here representing the applicant 11460 Gateway. Before I address Mr. Collins' legal remarks, a few background points that I think are important about this project. We've worked for the better part of 2.5 years with our neighbors to develop a project that meets city policy of bringing market rate and deed-restricted affordable units near transit, and also addressing neighborhood concerns about density, massing, and impacts. The project has changed substantially through the process as we've taken in public input and acted on that input. We were appealed only on the map and on the environmental to the CPC. At the Planning Commission hearing, it was disclosed by a representative from Council District 11 that the appeal was actually forged. So understanding the dubious nature of the appeal, the Commission swiftly and unanimously rejected the appeal and upheld the previous actions. That did start a new appeal process, at which time the law firm of Blum Collins and the Golden State Environmental Justice Alliance, as well as someone named Henrietta Conrad, appealed our actions. Their appeals are baseless, meritless, and have been repudiated by information provided by the planning staff, supplemental environmental analysis, and a lengthy letter submitted by our law firm yesterday. I would note that we're aware of who the Golden State Justice Alliance is, but Ms. Henrietta Conrad we were curious about, so we looked her up in the expectation that she was a neighbor, a resident, someone we could reach out to and talk to, as we have met with and spoken with many of our neighbors. Her LinkedIn profile, rather curiously, suggests that the one individual appellant is a legal assistant at the law firm of Blum Collins. A coincidence? I certainly hope so. If not, it's an unbelievable ethics breach that should have been disclosed as part of this process as opposed to by me up in front of this committee. As the planning department alluded to, the environmental documentation has been supported by a supplemental health risk assessment. Blum Collins and its consultants claim that the project, a 100% residential project, somehow creates an air quality impact through the construction process that would result in diesel particulate matter health risk to its neighbors. They didn't produce a health risk assessment or a full analysis. They produced only a screening analysis. So the effort was undertaken for a full health risk assessment, and that concluded, in fact, there are no impacts. They followed up with a letter that suggested that their environmental consultant suggested that a different threshold should be used that's applied to industrial facilities and power plants, a standard that's been clearly rejected by the City of Los Angeles for residential projects in other cases, including a recent project approved by this committee through findings that specifically address this issue for a residential project at Wilshire and Stoner that was 3 times the size of the project in front of you today. As the planning department alluded to, we would propose some supplemental findings for this committee's consideration and request that they be adopted in the course of you rejecting the appeal and upholding the SB 375 exemption. In summary, if I could take a moment just to summarize these findings, an M&D was adopted by the city on June 20th, 2017. It became effective July 6, 2017. A notice of determination was filed on July 7th. No challenge was filed thereafter. The CPC relied on that previously adopted mitigated negative declaration and found that it was lawful and fully analyzed the impacts of the project. These supplemental findings would suggest that there are no substantial changes to the project, no changed circumstances that the project has undertaken, and no new information submitted that would require supplemental environmental analysis in the form of a subsequent negative declaration or subsequent environmental impact report. These are the findings specified in CEQA Guidelines Section 15162. And specifically, these findings address the environmental threshold that was relied upon by the city to determine that there would be no health risk impacts to our neighbors resulting from diesel particulate matter. Secondarily, there are supplemental findings suggesting that the vesting map and the proposed alley vacation was done consistent with the law, Subdivision Map Act, Section 66499.20.2, and those findings indicate that the alley segment that's being vacated, only a small segment, is not currently being used. Empirical traffic data was taken on 2 days. Only 2 people traversed the alley at that time. Our client owns the entire parcel bisecting the alley. We own the underlying fee interest. It is not an illegal gift of public funds, and we ask the council to make those findings and make that clear in its determination today. Thank you for your time. I appreciate it.
Thank you. Okay, we have a number of public comment cards. Each person has 1 minute to speak. Gail Gold, R. Cato, Farzad Marshafeh.
I'm Gail Gould. I live on Butler Avenue. The idea of vacating the driveway alley is horrendous. It will impact the right-of-way. It will impact the entire neighborhood. And in addition, there is no way that a proper traffic impact has been done. I'm enclosing a picture of the gridlock that's on these streets before construction. You will have to put a traffic light Coolidge and Gateway, at Purdue and Exposition, and at Pearl and Sawtell. And also, you will have to change the amount of parking allowed on Exposition and Pearl so that cars can pass each other easily because of the increase in congestion, the incredible increase in congestion, which is already bad enough. You have ignored all our pleas and have only given them waivers and exemptions and nothing else. Thank you.
Thank you. Welcome.
Good afternoon. My name is Rosie Cotto, and I speak not as a West LA Sawtell Neighborhood Council Board member, nor as a Plum Committee member, but as a community advocate and resident homeowner. The project is not strictly residential. It contains commercial live-work units. The applicant failed to inform the community and the neighborhood council that 2 fully mature protected trees are growing on the project site that are protected by state law. The public right-of-way alleyway is valuable real estate. The Planning Commission knows the alleyway is required for any future development on adjacent properties and should not be vacated. A 5-story project of 56 feet with 129 units is overly dense for this area of mostly 1-story buildings and homes. Increased traffic density delays first responder response time and endangers the community. The general plan requires that the city protect the surrounding neighborhood. 4 healthy, properly maintained street trees at the site were decapitated November 3rd. However, a planning supplemental environment analysis filed November 6th states that the trees have been poorly maintained, haven't been topped, and in poor health. The project was overwhelmingly opposed by the West LA Sawtell Neighborhood Council at the February 22nd, 2017 board meeting. 7 no, 3 yes, and 1 abstention. In support of neighborhood councils, Mayor Garcetti publicly stated that he will only approve development projects that have been approved by the neighborhood council. Thank you.
Thank you. Farzad Charles Bullinger, Catherine Allen, and Edilberto Legaspi.
I'm the homeowner of the first house next to the proposed project, and I need the alleyway to access my backyard garage. This proposed project is massive and unbelievably dense with 129 small units compared to all other projects with the same lot size or even larger, and it will have severe negative impacts in our residential urban zone neighborhood. We neighbors from Colby Avenue and Butler Avenue completely object and oppose the city giving away public alleyway to a private developer for a private project and for helping them construct this dense 5-story building. We completely oppose the proposed high significant number of units density and bonus density of the proposal building. The developer should not be allowed to take away the alley to boost their own benefits and harm other properties of these 2 streets. This is a loss of our right and value of our properties. Having an alley is a legal right of all the people who live on Colby and Butler Avenue, not just this developer. The alley should remain as is, not vacant nor dead-end, and should remain public and accessible for both the homeowners and the neighborhood. The developer of this project should scale down the project to a size that will not require the use of the alleyway, but by no means the city is obligated to, nor should the city give away the alleyway, a legal public right-of-way of Colby and Butler Avenue to homeowners, to this developer.
Thank you.
This is a request from the 40 homeowners that signed a petition against this project on July 7th, 2017, and are directly affected by the project versus the one individual that came up with this idea and is not affected by it at all. The vote of the majority should be heard and considered. Thank you.
Thank you. Charles?
Hello. I'm Charles Bellinger. I'm a resident. I do not want the alleyway between Colby and Butler vacated for the proposed development. There's a few schools in the area, and any more increased traffic which will present a danger to our children. Thank you.
Thank you. Catherine?
Reset the time.
Yeah, can we reset the time, please? Thank you.
My name is Catherine Allen, a resident on Butler Avenue, and I'm here to speak against number 1, the alleyway between Butler and Colby. I want to keep the public right-of-way, and under no circumstance do I want the alleyway to be vacated for this proposed development. The residents do use this alley, and this project does involve gifting this alleyway to this project. Secondly, I do support asking for a full EIR to understand the impact in our neighborhood. Thirdly, the development on this site needs to be responsible and reasonable. understanding the traffic, parking, noise, light, pollution, public safety issues that do arise from this immense project, understanding that it's daunting considering that we are a 5-block neighborhood that's already been highly impacted by the traffic caused by the expo. A 3-story development is all this neighborhood can handle. And lastly, I just want assurance that none of the residents of this building will have access to parking permit 45, which we have been assured on numerous occasions that that was going to happen. Thank you.
Thank you. Adilberto Legaspi, not here? Oh, yes. Cameron Neff, Rick Neff, and Vabali Makam.
We were just talking about the safety of the alley. Opening up that alley would decrease the safety of that alley, which we closed down a few years ago. Opening up that alley would subject us to robberies, to trespassing, which happened a few years ago before we closed that out. And where that alley will open up to will be it opens up to a pedestrian area where all the kids walk and play at. It's just a bad place to put it. And that's it.
Thank you.
Afternoon. I really appreciate you guys finally hearing us out regarding this building. Neighborhood means a lot to my family. I grew up visiting my grandparents here every weekend, and I live in the house now raising my family. Which brings me to my biggest concern. Other than desperately not wanting traffic worse than it already is, opening that alley behind our houses on Butler would not only make it close to impossible for me to operate my business. I work with the city, I work with CHP, I work with LAPD, I tow motorcycles for a living, and I go in and out of that street 7 to 10 times a day. And the later in the day it goes, the harder it is for me to get out. Our way of life around the neighborhood has changed so many times already with the metro, other buildings, and I beg you to reconsider the size of this project. I appreciate you listening.
Cameron Neff, Rick Neff.
Committee, my name's Rick Neff, and I was born in 1945, and I've lived in LA all my life. I'm a Vietnam vet. I was a Hollywood cameraman for over 50 years. The house that I own on Butler has been in my family for 70 years. I've seen a lot of changes. The city planners and land developers have almost destroyed the neighborhood, and a new 5-story, 150-unit building, that's what I was told it was, would not definitely would add to the destruction. Not only is the traffic at rush hour like a parking lot, but it's very dangerous and confusing where the site is in question is located. When Santa Monica Freeway was built, it took away all but 2 very awkward, dangerous exits that we now have to deal with. There are a few plays, but there's 2 main ones. Gifting the developers any extra land and opening up the alley would make things a lot worse, which, by the way, was closed years ago to help the traffic situations, and the politicians then, in the past, promised never to give the land away and keep the whole area closed. I ask you to keep the site commercial only and under 2 stories. Thank you for your time.
Thank you. Bali, Laura Saltzman, Francis Ramos, and David Way.
Hi, I'm Vishali Makim. I'm a resident at 2470 Colby, and my biggest concern is that the alley between the Colby and Butler Avenue should not be vacated. I see that the plan shows that there is going to be a fire truck access from the alley, which should not be allowed because that will completely ruin the way the alley is used currently. And then also I also completely support the appeal filed by Henrietta Conrad and the Golden State Environmental Justice Alliance. If the government is willing to give the alley to the developer, then they should consider giving the alley to the neighbors between Colby and Butler. And then I also have a concern about the fact that the 2 protected trees that are going to be removed which is also something of a big concern. And the biggest concern is the traffic, noise, light, and air pollution, which needs to be completely studied, and a proposal should reflect all those concerns. Thank you.
Thank you.
Good afternoon, committee members. My name is Laura Saltzman, and I'm a licensed landscape architect and a nearly 30-year resident of the neighborhood adjacent to the proposed project. During this time, I've observed many changes in the surrounding community, and though I understand and accept the need for both adding, upgrading, housing, and commercial development along the Expo corridor, I am adamantly opposed to instituting changes which compromise the safety, tranquility, beauty, and security of our long-established and very viable single-family residential area. One of my primary concerns regarding the development is the potential loss of two healthy, well-established, and very beautiful sycamore trees on the perimeter of the proposed development. A change that, if allowed, would further degrade the urban forest, compromising wildlife habitat and minimizing the very substantial green buffer these trees currently provide between the project site and our low-profile residential community. My request is that these trees be retained in accordance with the efforts being made by the City of Los Angeles to conserve, protect, retain, and enhance LA's rapidly shrinking urban forest, which is increasingly more vulnerable to the effects of air pollution and climate change.
Thank you.
My name is Frances B. Ramos, and I have lived on 2498 Butler Avenue for almost 40 years. Since I moved here, this neighborhood has always been quiet and safe, especially for families and elderly people. I moved into my house with my elderly parents, got married, and raised my children here. I always felt comfort knowing that old or young, my family could be out and about in the safety of our neighborhood. This new development will only serve to bring a greater risk of danger to this community. We have already been negatively impacted by the traffic caused by the Expo lines. If the development is built as a 5-story complex, it will only bring further unwanted traffic, parking congestion, noise, light, and air pollution, and public safety issues. The alley between Butler and Colby is used by our residents for their garages and or access to their backyards. We want to keep our public right-of-way. Under no circumstances do we want our entire alleyway to be vacated, including the alleyway on the proposed development site.
Thank you. David Way,
Good afternoon.
Lisa McDonald, and Paul Desjardins.
Good afternoon. My name is David Way. I'm a homeowner on Butler Avenue. I'm here to express my concern regarding the proposed merger and vacation of the public alleyway related to the Gateway project. I'm a single individual living in my home, and my backyard is directly attached to the alleyway, and vacating the alleyway would expose a large amount of foot and vehicle traffic near my backyard, which is only separated by a 6-foot fence. This is a major security concern for a single individual living on his own, and I want to express that not only the parking, noise, and light and air pollution that will be affected. Lastly, I want to express that I support the appeal filed by Henrietta Conrad and the Golden State Environmental Justice Alliance. Thank you.
Thank you.
Good afternoon. My name is Leisha McDonald, and I oppose the Gateway project for 4 basic reasons. First, alleyways should not be given or sold to developers. Any section of the alley given for this development would mean that the entire alley is given to them. It is not their alley or our alley, it is a alley, one alley. Number 2, we were given assurances by the developer that they would include as part of the project getting speed bumps and signage to help reduce traffic that the development would bring. They have backed out of that. Number 3, we were also told the project would not have a Colby address. This is important to us because we use preferential parking. If they are given a Colby address, which is now on the plan, that means all 150-something residents will be able to buy into our parking system and visitor passes. Number 4, the traffic study that was completed was done in the summer when our local schools were out. We have a school right on Gateway Boulevard across from the project. and it was done in the middle of the day, not taking into consideration gridlock. So the traffic study was not properly done. Thank you.
Thank you.
My name is Paul Desjardins, and I have lived on Colby Avenue for close to 50 years. I oppose the plan to vacate our alleyway so a developer can build a bigger apartment building. I want to keep our public right-of-way open as it is now. I use the alley to service my property from time to time. Under no circumstances do I want the entire alleyway be vacated, including the alleyway on the proposed developed site. I also don't want the gates at the end of the alley come down for security reason. It keeps the graffiti taggers, vagrants, burglars, and people from dumping trash in the alley as they did in the past. Those activities all stopped when the homeowners of Colby Avenue and Butler petitioned and installed those gates 25 years ago. I also have issues with the developer putting a Colby Avenue and a Butler address on his project, so the fear of them issuing multiple hundreds of permits for our street, it doesn't sound fair. Thank you.
Thank you very much. Any questions on this? Can you, for the staff, the issue of the vacating the alley is an issue. Will some of the property owners there have, or the parcels have proper ingress and egress to their properties?
Yeah, so the site currently, there's an alley which runs south of the property and then runs effectively through the property. The alley vacation would be only for that portion, which is owned where the applicant owns either side of the alleyway. To the south of the subject property, it is gated, and it is gated all the way down to the next public right-of-way. That gate and that alley will not be affected by this vacation. So the alley, as it stands adjacent to these properties to the south, will not be affected in any way. It's currently gated. It's unimproved, so there's no concrete for the alley.
Oh,
that'll remain intact. That will not be affected as part of this alley vacation.
So when some of the speakers say that the gates will be open now, what does that mean?
Right. So the gate, there's no plan for the gates to be open. There is a fire department turnaround which is being proposed on the subject property that is adjacent to the alley. That's only there in the event that in the future the fire department were to come in and say we need to have some kind of access through this alley. That's not part of the project. That's not part of the proposal. So there's no consideration at this point that the alley would be opened up to the public. It would remain in its current condition. As I stated before, it's essentially now gated, so it's sort of a private alley for these single-family homeowners along their backyard, and that'll essentially remain intact.
Emergency vehicles could go in, for example.
Emergency vehicles could come in, but right now, it's, as I say, it's unpaved, so they would be running down a grass lawn.
And the portion of the alley that will be vacated, is that to build upon that area for the footprint of the project, or is that for other purposes?
Is for the footprint of the building, correct, yeah, and underground parking.
But they own both sides?
They own both sides of the alley.
Okay.
And, sorry, and just, this was also, we went through the subdivision process, the vacation of the alley was then also reviewed by the Department of Transportation and the Bureau of Engineering, both of whom said that the vacation was appropriate.
Okay, thank you. All right, well, thank you. Any other questions or comments? Based upon the record and testimony by Council District 11, we'll move to deny the appeal and determine that based on the whole of the administrative record, the project is exempt from CEQA pursuant to Public Resources Code, and find that the project is a transit priority project pursuant to PRC, and find that the project is a sustainable communities project that meets all of the requirements of subdivision A and B, and one of the requirements of subdivision C of section 21.155.1. All right. Yes.
Terry Kaufman, Messiah City Attorney's Office. So if it's the committee's pleasure and they want to incorporate the findings that were summarized by the applicant, now would be the appropriate time to do so. And also, as part of your motion, you should make the findings that they're actually listed in the Planning Department report and incorporate those, the MND mitigation measures, mitigation monitoring program, again, based on the whole of the administrative record. So this has the exemption and the MND.
Okay, we'll incorporate the findings and the suggestions by the city attorney into the motion with respect to the M&D. Okay. Any objection? Seeing none, so ordered. Thank you very much. Oh, there is no public comment after public comment has been taken, sir. Okay. We'll call, next item is item number 7, and Mr. Harris Dawson will call this item to order. Thank you.
Would you read item number 7 into the record?
Sure. Councilman, item 7 is an appeal by Renee Becknell and Michael Fisher. This is a building and safety haul route to export 4,800 cubic yards of earth for the property located in CD5 at 1047 North Somera Road.
Excellent, thank you. We have a staff report on this.
Dean Elkinawi, Building and Safety. This item was heard on October 24th, and the categorical exemption was accepted by the Building and Safety Commission. If you have any questions regarding the haul route, I'm here to answer them, and we have a representative from City Planning to answer any questions regarding the environmental document.
Got it, thank you. We have a good amount of public comment on this matter, but we start with the appellant, Ms. Becknell. Speak for 5 minutes.
Thank you. Does the other appellant also get 5 minutes?
Yes.
Thank you. I'm Renee Becknell. I live at 1052 Somera, which is across the street and over one from the subject property. And we're asking that the haul route permit be stopped and withdrawn for now. All we really want is this project to be reviewed in an appropriate manner. We live on a slip of a street. It is a sliver of a street. It's called a substandard hillside street, according to the city records, that's on the top of a narrow ridge line. It's a cul-de-sac. It's one way in, one way out. That's it. There's no other outlets. We are in a very high fire risk zone. We are less than a kilometer from an earthquake fault zone. There have been landslides in the area just 2 or 3 doors down from this, which the other appellant will address in detail. There have been, in the last 2 years, with respect to projects that have been approved under the current city regulations, which will appreciate the more restrictive baseline hillside ordinances, we appreciate that. Even with those additional constraints, 3 projects have caused slope failures on this street, even though they've been approved. We're begging you to help us not let that happen again with respect to this project. It's a large project. No one's disputing their right to build there. We just want to make sure that there's been adequate geological study, that there are adequate constraints in place to ensure the safety of the whole neighborhood. Look, we're not any CEQA experts or anything like that, but it appears to us, we understand the blanket exemption that's granted, but certainly given these cumulative effects of the building that's gone on in the street, for instance, there are six large, full ground-up builds on this small cul-de-sac, 6 of them going on right now. That changes the topography of the whole hill. That needs to be taken into account. And the only way to do that is to do a geological review and analysis and soils of not just that specific sliver of property. It needs to go for the whole geological formation that's right along there, which includes property that has had landslides, that directly to neighboring properties have severe erosion issues that have only been magnified over the last several years. We're really asking for your help on this. Moreover, there really are some doubts and questions as to how this project has proceeded. The applicants first notified everyone that they were removing 1,900 cubic yards of dirt. 2 days before the hearing on that, it suddenly changed to over 4,000 cubic yards of dirt. We had no opportunity to think about this, to get help on this, and yet the commission, heard this and granted this without any notice. That's no proper notice being given to us. So it just does not bode well for the whole project. It's a very disingenuous way to approach it that doesn't give people any comfort level as to how they'll proceed with the project as a whole. We have general extreme safety concerns within this neighborhood. We've, just a couple weeks ago, there was a dump truck coming up a hill and a trailer moving a large earth-moving piece of equipment coming down the hill, lost control of its brakes. They crashed. We had an enormous diesel spill. The dump truck's the only thing that stopped this other vehicle from going into someone's living room, literally. We've had, numerous issues with trucks speeding on the street. We've had, people's mirrors and cars damaged consistently. There's inadequate restrictions on this hauling, even as approved, to help prevent any of that. We're at a point now, it's a family neighborhood. People don't let their children walk dogs in the street anymore. It's ridiculous. You can't get through. You absolutely can't get through. So we're asking that you help us on that end as well. And just moreover, I think this seems like putting the horse before the cart. How on earth can you grant a hauling permit when they don't have a grading permit that's been approved? The grading permit determines how much they can cut into the hillside, how much can be removed.
That's your time. Thank you.
Thank you. Appreciate it.
We have a second appellant, Michael and Sharice Fisher.
Who am I talking to?
Talking to the mic.
Okay.
There you go.
All right. Just briefly, Bel Air, as you all know or may not know, was started as a planned community in 1922 and was controlled in its developments and maintenance by Alfonso Bell. That stewardship then passed in 1942 to the Bel Air Association. And under their guidance, the community was developed in a very cogent manner, which preserved the environment and also allowed building. That CCNR lapsed in the 90s, and we then fell under the purview of LA City. The hills, as you know, are not the flatlands, and we're subject to a bunch of other concerns that building in the low areas are not met with. Specifically, as Renee talked about, is the susceptibility of the hillside to landslides. Now, what you need to know is that obviously one slope and one ridge line is not the same as all other ridge lines. And what we have here is a ridge line that has proven itself incompetent over the years in a very substantial manner. There was a landslide in 1959, and again another landslide in 1965 in that same slope. This involved 4 adjacent properties removed from the site in question by less than 50 yards. That slope lay fallow and was remediated by the city to standards that are substandard by today's measurements. And by that I mean, if the city was to remediate the slopes currently, it would involve retaining walls, pylons, etc., etc. Our properties are vulnerable due to the lack of involvement of the city in maintaining those hills to a proper level. So what we have now is a builder who comes in, who wants to develop a hillside according to whatever the restrictions are. But what they don't take into account, and what we ask you to please take into account, is what the impact will be on our adjacent properties. In the last El Nino, that same slope was subject to a slide which involved a swimming pool, which broke free, slid down the hill, flooded the house below it, took half of a property line of my adjacent old property. The city then comes in, red tags that house, throws the people out, and makes them build a retaining wall, costing them in the realm of $300,000 to $500,000. We don't need that happening again. Please, I am asking you, let's just do the right thing. Do the right thing that you would want if this was going up next to your house. Do the right thing if your family was living there. Do the right thing because it is the right thing. I'm not against development, believe me, but development has to be cogent, it has to be measured, and it has to be safe. Safety, health is your first
Excuse me,
concern.
hold his time. We've got talking at the back door. If that can stop immediately, folks can go in or out because we can't hear. Thank you.
Thank you. And so really what we're asking for you to do is, we don't want to stop this project. We just want to make sure it's safe. Safe for everyone. Not just safe for the people who are building there, but the impact that they will have on the adjacent properties. And this has been shown time and time and time again in the hills. You can't do anything in a vacuum. A hillside is a living organism. It responds to what's done in one place by reaching out in another place. And this has been demonstrated again and again and again. So we ask you to please halt this route, because it is, as Renee say, putting the horse before the cart. The proper geologic investigation has to be done on the entire hillside and the adjacent slope, not just this one property. Because I have pictures here that you can see right next door. They have concrete pylons. They are failing. They are cracking. The concrete is separating. This is an active slope. This is a weak slope. This is a slope that is doomed to failure in time. And what we do to make that move along faster is not in the best interest of the city, the neighborhood, or our families. What happens if there's an earthquake? What happens then? All this stuff is going to come tumbling down. Not necessarily the one with the 100 pylons going 60 feet to 150 feet into the earth, but what happens to the adjacent properties when those pylons start shaking? The hillside is destabilized and starts to fall down. All we want to know is that our homes are safe.
Thank you.
Safety.
That's your time. So we have the applicant, Sean Nguyen, and I think also Yvonne Patterson. You all will split your time. And you're not either one of those people. Yes, sir.
Mr. Chair, yes, Ben Resnick, and I think I'll speak on behalf of the applicant.
Okay.
I think a card was submitted. Good afternoon, members of the committee. Ben Resnick with Jeffer, Mangles, Butler, and Mitchell here representing Ms. Patterson, who's here with us today, who's the owner of the project, and her architect is here should you have any questions. So let me just begin by saying the project is a fully compliant project with all the rules, regulations, and ordinances. And this project did get a very thorough review on the soils and geology, full study done. Building and Safety reviewed it, and a year ago, the soils and geology report was approved by Building and Safety. Since then, the architect has been working on the plans for the building, and I think a misconception in the community is that the haul route can't occur, or the approval of the haul route should not occur until after the grading quantities have been figured out, and they have been. And so otherwise you couldn't design the house. So the haul route needs to get approved before a building permit can issue, and that is common procedure in the city. So all we're asking for today is the haul route process. Our client is very sensitive to the concerns raised, and we're also very sensitive to the issues and concerns raised by the council office
There are right now about 19 different conditions imposed by the Department of Building and Safety on this haul route. Very detailed conditions on number of flagmen and on timing and limitation of hours and limitation of days, and no two vehicles can pass at the same time and things of that nature. But I understand that you're going to get additional conditions being imposed that have been shown to us earlier by the council office. And our client has agreed that she would accommodate those additional conditions as being requested, again, in an effort of showing good faith and trying to make sure the haul route itself, the haul route, is safe. And that's what the haul route is really about. Now, on the issue that's been raised in the two appeals, we don't take that lightly either. We take it very seriously. Those issues have to do with safety and concerns that the appellants have raised pertaining to slope stability. The whole neighborhood certainly sits on a ridge line. There's a history of certain activity. But the fact is that we're very confident that our soils and geology takes all that into account, and what's being proposed here is safe. But I understand that there is another forum, and we can certainly continue to discuss issues pertaining to soil stability and look at material or evidence that the neighbors may have and share that with our soils and geology engineer and with the Department of Building and Safety, quite frankly, if they choose to take a second review. We're not opposed to that. That would certainly be respectful of the concerns raised by the neighbors. But they really have nothing to do with the actual hauling operation and the hauling process, which is a prerequisite to us being able to get to a place where we can finalize and get a building permit issued. So we ask you to deny the appeals on the haul route that's before you. But in reality, I think the issues raised by the appellants are going to be dealt with. And we're certainly going to work with the council office, which has obviously asked us to agree to that and asked us to work with building and safety and the community on these issues. And we will certainly do that. But for purposes of what's before us today, the mechanics of how the haul route should be addressed, I think you have adequate conditions, and as I understand it, there may be a few more added by the council office. And with that, I'll waive the rest of my time. Thank you.
Thank you so much. We have a number of public comment cards. The first one I have is from someone named Wayne. Looks like he's not here. Second one is Ron Matsunaga. Helen Matsunaga, please pardon me if I'm mispronouncing your name. Roland Dacer. You all can approach. After that, Stephen Robbins.
I'm Dr. Ron Matsunaga, on the Samara Road resident.
I'm his wife, Helen Matsunaga, and we've been residents on Samara Road for about 48 years. We bought a burned out, thank you. We bought a burned out lot. Remember the 1960 had that horrendous fire? Well, all of Samara, not all, but most of Samara Road houses were all burned down to the ground. But anyway, we purchased one of the burned out lots, and we built our home, and we raised 4 children. And during the lifetime that we've been there, we've seen some landslides on our hill, and it's just horrendous.
Thank you.
Thank you.
Jonathan Burrows. If I already called your name, come on up if I called you already. I'm just trying to get people in the queue. Arlene Chang, Ernest Wright. Yes, sir.
My name's Steve Robbins. I'm a resident on Samara Road, and what I want to speak out about is most important to us, the residents, and that's the safety. As you heard, Samara Road is a substandard hillside street. What that means is it's one lane in, one lane out, and if there's an emergency that occurs when these dump trucks are lined up on the street, an ambulance can't get up. A fire engine cannot get up. We recently had a fire in our neighborhood. We recently had an accident, and we want to make sure that when you approve this haul route, that you're not doing it while another haul route is in existence, because two dump trucks cannot get past each other on the road at the same time. We feel it's very important that you look at the big picture, at all the construction projects going on the street, and only allow one at a time. Otherwise, somebody's going to get hurt, somebody's going to have property damage, and we'd like you to very seriously consider that.
Thank you.
Safety of our neighborhood. Thank you.
Thank you. I have Barbara Frankel and someone named Pilt, P-I-L-T, it looks like.
My name is Barbara Frankel. I have lived on Somera Road for 52 years, and things have been very much changed over these years. I raised 2 children there who played on the street, which is no longer possible. Children cannot play on the street because of the dangers involved in the comings and goings of so many trucks and heavy machines. They block people trying to get in and out of the street. They make it difficult for fire personnel and ambulance services to get through without someone running into a house to find a construction worker's car or truck to be moved so that somebody can be helped in a serious situation.
Thank you.
Thank you.
All right, I think that exhausts cards on item number 7. If I think I called you, Mr. Wright. Did you hear me call? Ernest Wright? Yes, we called you. We called Arlene Chang. We called Arlene Chang. You guys got to come up. Pardon me? I don't have a Fisher. Yeah, I don't have a Fisher, but I have Arlene Chang. Come on, go ahead.
Mr. Chairman and members of the committee, my name is Ernest Wright. I'm a resident of Samara Road. I live on an adjacent property to the property that is under consideration, and I have grave concerns about the geology of this particular site, and this site and the adjacent houses, there are 6 of them, and the geology has not been done to our knowledge, and we would like to appeal this decision on the haul route until we can be assured that the geology is appropriate and all the safety considerations have been taken into account. Thank you.
Ms. Chang?
I'm Arlene Chang on Samara Road. I'm reading a letter from the adjacent property owner. We are the Huber family, the current owner of 1041 Samara Road, that is adjacent to the above-mentioned project. Our quiet, beautiful neighborhood has undergone some significant changes in the past few years that has been disrupted and not enjoyable to live through, but the proposed project has brought a new level of worry to all of us. We love our home, and during the purchase process, we could not secure finances or insurance without a geological survey performed to verify the safety of the structure. How could a new development of this magnitude not be required to perform this as well? Our main home is constructed on pillars that reach and are anchored to bedrock 6 feet below. However, our guest home does not.
proposed project plans to be disrupted to the earth located adjacent to this property.
Thank you. I think that concludes our speaker cards for this item. If there are questions, members, on this matter, Mr. Price, Mr. Englander, Mr. Blumenfeld? Hearing none, we will move to deny the appeal and see that the following conditions are placed. 1, a delay in hauling activity, a 3-month delay from approval in order to give time for other projects to finalize all heavy equipment activities. Number 2, reasonable parking restrictions for construction vehicles. Restrict all construction work vehicles to the west side of Samara and only along the street frontage of the property and 2 lots south. Number 3, staging activity to be on site. Once demolition of the existing structure is completed, all construction and hauling staging will be performed on site. Number 4, flagmen. The use of flagmen will be required. And number 5, coordination. Reach out and arrange construction schedule for better coordination with projects surrounding this project. That concludes the conditions. It's been moved. Gentlemen, it's been moved. Second by Mr. Englander. Hearing no objection, that'll be the order. Thank you. We have one public comment card. Mr. Wayne from Encino.
You know, I went in, I put in speaker card on item number 7. You call my card again. You keep violating the Ralph M. Brown Act. You just gotta go down to district court. And you gotta see there's a lawsuit pending against you for the same shit you did in January 2016. Crazy man. Why are they doing this? I wait all this time for 1 fucking minute. I don't call my speaker card. But that's gonna change real soon. Because what you're gonna find out is there's something called unlimited liability choo-choo train, and it coming to City Hall real soon. So just remember, this is the 9th time in the last 16 months you have dished my cards out on an item. And then finally, I'm glad that Councilman Kern Price and his lovely wife are living in your district and not that crazy motherfucking night district. Have a good night.
Dude, your time's up. Yes, ma'am.
Terry Coppin, Mesilla City Attorney's Office. I just wanted the record to reflect that you did call Mr. Wayne's card, and he was walking around, he wasn't paying attention, and
Yes.
then you mentioned it again, and he was walking around in the back and didn't come forward. So I just want the record to reflect that.
Thank you for that addendum to the record. The record will also reflect Mr. Spillman continues to disrupt the meeting,
Trust white people. I can't goddamn.
even as we try to adjourn the deliberations for today. And with that, we're adjourned.